Class will be a continuation of our previous class on legal sections. So quickly to revise, 272 IPC states about adulteration of food, 273 sale of noxious food, 274 adulteration of food, 275 sale of adulterated drugs, 274 adulteration of drugs, 275 sale of adulterated drugs, 284 states about negligent conduct in relation to poison, and 328 is administering poison in intent to cause, hurt or facilitate offense. We have seen all of this in detail in our previous class. Now let's proceed to the legal duties of doctor in a case of poisoning. The first medical duty is obviously to save the life of a person. It's the most important duty. Then the legal duty is to intimate the police, right? Under section 39 CrPC, the doctor must intimate the police even for suicidal poisoning also, okay? In homicidal poisoning, obviously the doctor must and should intimate the police. In suicidal poisoning, however, if it is just an attempt to suicide which is not punishable, this need not be compulsorily informed to the police. If the suicide has succeeded, then it needs to be informed. In case of an attempted suicide, there is no need to inform. Now 176 IPC talks about the non-compliance of the doctor with the above rules which we have seen. 177 IPC talks about the doctor giving a false information in cases of these suicide or homicide. Now the second legal duty of the doctor is preservation of the evidence. A very, very important duty of the doctor, right? Homicidal poisoning, the gastric lavage material is the evidence, and if the doctor fails to preserve this material or amounts to disappearance of the evidence, this is punishable under IPC 201. Okay, so if preservation of evidence is lost by the doctor, it's punishable under IPC 201. Then the third and most important duty is attainment of dying declaration. If the patient is about to die, the doctor should arrange for a dying declaration. We have seen this in detail about dying declaration in our previous classes, right? So the three legal duties of the doctor are to inform the police, number 1, number 2, preservation of evidence, number 3 will be collecting dying declaration. Now what is the drug and cosmetics rule? It was given in 1945. It gives many schedules. It states that every drug will be listed under one particular schedule. Every schedule has a specific regulation, and once a drug is placed in a particular schedule, it must be maintained under the rules of that schedule itself. This is stated under drug and cosmetics rule. Now what are these schedules? Schedule C is for when the drug contains biological products, E when it contains poisons, F is also for poisons, G is for hormones, hormonal drugs, H is for drugs sold only on prescription of a registered medical practitioner, I is for list of diseases for which no cure is advertised. Then Schedule L is including antibiotics, antihistamines and anti-cancer drugs, and Schedule X indicates drugs of abuse. X means don't use, so that is for abuse. Okay, so please remember these schedules, they are very important for your exam. Now let's look at the offences related to abortion and childbirth. 312 IPC deals with the miscarriage which is done with the consent of a woman, and 313 IPC talks about miscarriage done without the consent of the mother. Then 314 IPC talks about the death of the mother caused by a miscarriage. 316 IPC talks about the death of an unborn child. It can be taken under culpable homicide, and the punishment will be 10 years of detention with fine. 317 IPC talks about abandoning a child, and 318 IPC talks about concealment of birth. The punishment can be 2 years of detention with fine. So please remember 312 IPC miscarriage with consent, 313 without consent, 314 death of the mother, 316 death of unborn child, 317 abandoning a child, and 318 concealment of birth. Now let's look at this very, very important act, that is Transplantation of Human Organ Act. It was enacted in 1994 and the latest amendment was made in 2014. Okay, it was mainly enacted for removal, storage and transplantation of human organs. Okay, it is also meant to prevent commercial dealings of human organs. Now, any part that is removed cannot be replicated by the body, right? This act also enables about the brainstem death declaration. Okay, now who can declare this brainstem death? It is a team of doctors who can declare brainstem death. The team contains the doctor who was treating that patient and the doctor who is in charge of the hospital. Also, it has to include the neurologist or the intensivist or the anesthetist or neurophysician or the neurosurgeon who was treating the patient at the time of death. Only these people in the team can declare a brainstem death. Now, there are a few reflexes that have to be checked and verified before a person is called as brainstem dead. Okay, the light reflex mediated by second and third cranial nerves, which have the nuclei in the midbrain, that should be checked. Midbrain plus pons is checked by the vestibulocular reflex via the third, sixth, and eighth cranial nerves. Again, the doll's eye reflex also with the third, sixth, and eighth cranial nerves. For medulla, the gag reflex is checked, which is sent via the 9th and 10th cranial nerves, and for the pons, corneal reflex is checked via the 5th and 7th cranial nerves, right? So, number 1, light reflex, vestibulocular reflex, doll's eye reflex, gag reflex, and corneal reflex. All of these are to be tested before brainstem death is declared. Okay, apneic test is for checking the respiratory center. Okay, now if all these reflexes are negative, then the person is declared as brainstem dead. So many reflexes have to be verified before you call a person brainstem dead. So why are we talking so much about the brainstem dead person? Because they are eligible to donate a lot of organs. Okay, these are known as the cadaveric donors. Now, what is the difference between a living donor and a cadaveric donor? The living donor can donate to a near relative such as son, daughter, spouse, etc., and can donate to a non-relative also. Then, however, he has to get a prior approval from the authorization committee. These are the rules for a living donor. He can donate to a near relative or non-relative also, but he has to get a prior approval from an authorization committee. Now, let's look at organ transplantation. The first thing is swap transplantation. If the living donor for a person is a near relative, but the donor and the recipient is having a mismatch and there is a similar pair elsewhere who are having a mismatch, the organs from these two donors can be swapped between these two recipients. Is it clear? If a near relative and the recipient, and there is another set of relative and a recipient, but they are having a mismatch, then the organs from these donors can swapped from one relative to another. Authorization should be done by the donor. That is, any person above the age of 18 years can be a donor at his or her own will. Okay, and if the person expresses his or her willingness to donate an organ, however they die after his or her death, the authorization should be given by a person who is under legal possession of the body. Okay, whoever is possessing the body legally, they should give the authorization for transplantation or donation of the organ from this donor after his or her death. Now, once the brainstem death has occurred, the doctor has to get prior authorization from the postmortem doctor that the organs are not required anymore for determining the conditions of death. Okay, so first the postmortem doctor should give a clarity that he does not require the organs for any further forensic study, then they can be given for donation. Now, what is the punishment for organ donation? When a doctor removes an organ without appropriate authorization, he is imprisoned for 5 years along with a fine. So, without authorization, imprisonment for 5 years. Okay, if a doctor conducts this offence, his name will be removed from the state medical register. Okay, first offence, only 2 years the name will be removed. If he does it for the second time also, permanently his name is cancelled from the state medical register. Okay, if a person is involved in commercial dealing of organs, please make a note of this. There will be imprisonment for 2 to 7 years along with fine. Commercial dealing of organs, that is illegal dealing, imprisonment for 2 to 7 years with a fine. Now, let's proceed to Juvenile Justice Act. The Care and Protection of Children Act was enacted in 2000, but amendment was made in 2015. Now, who is a juvenile? It's a person who has not completed 18 years of age. Anybody less than 18 years is considered a juvenile. We all are familiar with this fact. Okay. It is not for punishment of child, but mainly meant for the socio-legal reforming or rehabilitation. Okay. This act mainly identifies the child into child in conflict with law and child in need of care and protection. Now, who is this child in conflict with law? It's nothing but a child who is less than 18 years of age and is alleged to have committed an offence. So, he is in conflict with law. This is a child in conflict with law. Now, the Juvenile Justice Board has 3 members. These are the first class magistrate and 2 social workers. Okay, one of the members should compulsorily be a female. Okay, the first class magistrate plus 2 social workers form the 3 members of the Juvenile Justice Board. Okay, a juvenile between 16 to 18 years of age who has committed a heinous crime such as a rape or a murder will be tried as adults only. They will no longer be considered as juveniles because these crimes are absolutely loathable and heinous, right? And the punishment will be same as adults. However, if the juvenile has committed a crime, the punishment is reformation. If it's not a heinous crime, it is reformation or rehabilitation. They are sent to reformatory schools which are known as brothels, where they are helped with rehab for 3 years. Now, what is euthanasia? We know that it's nothing but mercy killing, right? Active euthanasia and passive euthanasia. There are 2 types. What is the difference? In active euthanasia, the drug administration results in death of the patient. Okay? In active euthanasia, you give a certain drug in order to cause the death of the patient. However, in passive euthanasia, the person is usually on life support system, and when you remove this life support, there is death of the person. You are not directly giving any drug to cause the death. This is known as passive euthanasia. Now, there is another type of classification that we have to know. What is voluntary euthanasia? It is done as a wish of the patient with the patient's consent, and it is legal in India. Involuntary euthanasia is illegal in India and it is done against the will of the patient. Involuntary means it is done against the will of the patient, so it is illegal in India. Okay. Then non-voluntary euthanasia, the patient would be in a condition of coma where the patient is not in a position to give a consent. This is considered under non-voluntary euthanasia. Now let's look at living will. It is a document mentioning the patient's wishes regarding the treatment options in case he leads into coma or terminal illness. Okay, so anyone who is anticipating to end up in a coma or a terminal illness can make something called a living will. It's a document. Okay, it will guide the physician about the further course of treatment that the physician will have to take in this patient. Okay, any citizen who is a major can write the living will. Okay, it should be attested by a first class magistrate. Please remember, the living will should be attested by a first class magistrate, and the person can also nominate a relative in the living will to decide on the treatment options. Suppose the person is unable to decide because of his comatose condition, he can nominate